My pleasant namaskarams to all of you. If we revisit digital search powers under the IT Bill 2025, we will understand that this central government, rather than the persons who are at the helm of the affairs, through our Prime Minister and the Finance Minister, wants to introduce a provision in the Income Tax Bill 2025 allowing tax authorities to access under the Income Tax Bill 2025 an individual's virtual digital space during search and seizure operations. Is it not interfering with the personal freedom of an individual or the firm, whatever it is? We want to have a peaceful life at first, and then right to life is a fundamental right. This section 132 of the income tax, it permits search and seizure in physical spaces. The proposed bill extends these powers to digital spaces, raising concern over privacy and potential overreach. Now already we are coming across cases of digital arrest. The old people, or even for that matter many number of people, have become scapegoats of this digital arrest. On one side we are saying that there is no digital arrest. Now this digital search and seizure by having powers to digital spaces, raising concerns over privacy and potential overreach. Digital spaces encompass more than relevant tax investigation data involving multiple stakeholders. Accessing digital spaces like social media can expose information about family, friends, and professional contacts. This bill broad definition of virtual digital space includes emails, cloud drives, and social media accounts. Please understand, if this is allowed, it amounts to a violation of transparency and accountability. In the bill, there is a contradiction. India's proposed income tax provision grants sweeping access to digital personal data without warrants, relevance, thresholds, or any distinction between financial and non-financial information. But as you know, that the Honorable Supreme Court, in the case between case Puttaswamy retired versus Union of India, directly contradicting this power, already gave a decision. Any restriction to individual's privacy must meet a fourfold test according to this judgment. Whether this digital search powers under the IT Bill 2025 is really ready to meet a fourfold test. One is proportionality was key, requiring state action to pursue a legitimate aim. Second is satisfy the necessity and adopt the least intrusive means available. But this particular power under section 132 of the IT Act 1961, if extended to digital spaces, then as I said that all information about family, friends, and professional contacts and whatnot, everything will be exposed. What will happen then? The state will almost ruin the lives of innocent persons. We are not here to rule against the constitutional fundamental rights and constitutional provisions. Allowing unfettered access to personal digital data in the absence of judicial oversight or safeguards fails this standard. The standard that is fixed by Honorable Supreme Court in case Puttaswamy retired versus Union of India. Digital enforcement altogether, I don't say to abandon it. Yes, definitely there must be some powers in case of necessity to have some powers. But proportionality, legality and transparency, these must be looked into. The right of privacy shall not be allowed to be eroded under the guise of search and seizure in digital spaces. Definitely, the unchecked surveillance in the name of compliance is not governance but overreach. Select committee, which is reviewing the bill, is planning, rather discussing to shorten or define this natural virtual digital space by narrowing it and mandates prior judicial warrants and disclosure of reasons for such access to digital content, in addition to establishing mechanism of redress for grievances of the aggrieved individuals. Whatever it is, where is the urgency for this? But the Parliament, through the Finance Minister, already expressed its intention and provision is made. It is a judicial oversight and privacy standards. The Supreme Court in 2023 already gave some interim guidelines for digital device seizures. The global standards emphasize statutory protections and procedural safeguards for search and seizure. Even in the Canada and US, there is a established rights against unreasonable searches requiring warrants and reasonable grounds. But the bill which is now proposed is giving unfettered access to personal digital data without safeguards, fails privacy protection standards. So, enforcement should adhere to the principles of proportionality, legality and transparency. So we need to have redefinition of virtual digital space. The recommendations such as judicial warrants and establishing a redressal mechanism for individuals, it is all with the aim to ensure that regulatory actions do not erode privacy rights, avoiding unchecked surveillance in the name of compliance. So please see that we are protected.